We filed this petition at 11:45 p.m. on Friday. Today is Monday, so it's only 2 days gone. We have been able to serve the parties, IEBC, the president, and other parties electronically as is required by the law and physically as is required by the law as well. It is now time for us to wait and see the responses of Jubilee. I'm already seeing some ill-informed jibes from the likes of Murkomen, who most of the time speak before they think, dismissing whatever we have put in court. But that's not the issue. We have gone to court because we know we have a good case. We've gone to court because we know that the elections were not conducted in a free and fair and accountable and credible manner. We've gone to court because we believe, as the Constitution provides, the courts are the last avenues of political battle to ensure that what ordinary mortals have been unable to do out there, the judges of the Supreme Court can unravel and tell the country the truth. We've gone to court knowing that the case we have placed before the Supreme Court is going to be an eye-opener. One, on how the elections were misconducted. Two, on how the losers were declared winners. Number three, how there was institutionalized and systemic cheating, rigging, and eventual theft of the elections through use of IT. And it's instructive to note that the man that President Uhuru dismissed from office for corruption, called Chirichir, is the same man he invited to be the chief agent of his party. And the Chirichiri had been dismissed because of dishonesty. So he came with the same behavior of dishonesty to help in stealing our elections. We have said before, and I want to repeat, that last elections, 2013, we went to the Supreme Court to challenge the outcome for reasons that Kenyans know. The misconduct of the Supreme Court at the end of the case, everybody knows. You cannot, as a judge, and I've been a magistrate before, and I've practiced law for the last over 30 years, you cannot, as a judge, listen to such an emotive legal process and deliver a 2-minute judgment the way we saw Willie Mutunga, the then Chief Justice, do.
So
what we're expecting now is for the Supreme Court to hear both sides, because that they must do. That's what the Constitution expects, and natural justice requires that they hear both sides. There will be evidence and counter evidence. We want to hear if they uphold our case, for them to convince Kenyans that we had a case. We want to hear if they do not uphold our case, to convince Kenyans with reasoned judgment that we didn't have a case. Then, as good competitors, we will address that issue at that time. But we are not expecting, and we hope it will not happen, a repeat of 20 and concrete arguments. You end up with a Chief Justice sitting there, fidgeting, and delivering a 2-minute judgment and telling you reasons will come later. Kenyans don't want reasons to come later. Kenyans want to hear reasons why NASA is crying foul that the cheating in the elections has robbed us of victory. And Kenyans will want to hear the judges say, if they so find, why they think that our case has not convinced them. Okay. That is what justice is all about.
And let's, in a scenario where the Supreme Court says that probably there's no concrete evidence to warrant a runoff or maybe the nullification of the elections, what next for NASA?
I don't want to speculate. We have gone to court with the confidence that we can and shall win. So I'm looking at the positive side of our case. I don't want to speculate on the negative side of our case, because I can't go to court and say, I'm going to court but I will lose and then I do this and that. No, because we know we have a case and we have gone there with multiple prayers. We've asked the court if they so wish to declare our candidate the winner, if they so wish to find that these malpractices and rampant rigging of elections result into a repeat of the election, whichever decision they make, because we have several prayers. And remember, in law, when you go to court, there is always the final prayer, that the court may deem fit to grant any other and further orders that they desire. So they may very well even give orders beyond our prayers to make the country face a better trajectory in terms of politics and electoral processes. So we are waiting for them, and the ball is squarely in their court. Like I said yesterday, but one at the burial of Chris Musando, what is on trial here are multiple faces of our country. The process of elections is on trial. IEBC is on trial. The management of elections is on trial. The Supreme Court itself is on trial. Kenyans are watching to see whether it's a court worth being called a Supreme Court in an environment and a jurisdiction of our nature. And this will depend on how they conduct themselves throughout the hearing of the case from the beginning to the end, and how they'll deliver their judgment, so that Kenyans can then vest and invest hopes in the arbitration process, where the political arena has become too hot. We should go to cool it in the judicial system.
Right. And when you have two sides, one saying that the elections were not credible, the other one is saying that the elections were credible, don't you think that the push and pull is probably putting the court in a situation where that independence that it enjoys is probably under threat?
Courts are arenas for dispute resolution. And you can't go to court if you don't have a dispute. And you can't have a dispute if you don't have two opposing sides. So these two opposing sides of we won and you didn't win is what we have taken to the court. And the polarities of the court should not arise. If you accept to be a judge of the Supreme Court of Kenya or any judicial process, your duty is to absorb that heat, cool it down, and give people a judgment that satisfies the winner and the loser. So we really don't see any situation where that the court will be divided, or the court will be demoralized, or the court will find it difficult.
And then finally, there is the county allocations. What are the plans that the Senate has in terms of what goes to the counties? Are you going to be advocating for more allocation, just like NASA did advocate? Or